Module 3. Post-Employment Benefits. Introduction. Aside from severance and unemployment, there are rules in place to ensure that employment benefits can be maintained or transferred by people changing jobs in as smooth a manner as possible. This module will focus on transitioning of health insurance and retirement benefits, including Social Security and private retirement accounts. Health insurance portability. Unexpected job loss can be difficult to cope with financially, professionally, and personally. When an employee loses her job, she also faces a loss in wages and employer-provided benefits. To ensure that workers and their families do not suddenly lose health care after losing a job, Congress passed two important health care insurance protection laws: the Consolidated Omnibus Budget Reconciliation Act of 1986, usually referred to by its acronym COBRA, and the Health Insurance Portability and Accountability Act, or HIPAA. Consolidated Omnibus Budget Reconciliation Act of 1986. The Consolidated Omnibus Budget Reconciliation Act, or COBRA, protects workers and their families from losing health insurance benefits under certain circumstances for a limited time if the employer suddenly becomes ineligible for coverage. COBRA coverage, which is intended to maintain the medical coverage formerly available under an employer's plan, extends to covered employees, their spouses, and dependent children. COBRA protections apply when an employee is separated from his job or some other life events occur. Qualifying events include voluntary resignation, involuntary termination for reasons other than gross misconduct, reduction in working hours, death, or divorce. The employee must have been enrolled in his or her employer's health plan to be eligible for COBRA protections following a qualified event. COBRA coverage must be activated within 60 days following the qualified event, so workers must quickly decide whether to elect COBRA benefits within this time frame. Under COBRA, private employers with 20 or more employees and all state and local governments must temporarily extend coverage of group health plans to covered workers. The time for which COBRA healthcare coverage is available depends on the nature of the qualifying event. When a covered employee has his working hours reduced or is terminated, COBRA benefits are available for a maximum of 18 months. For other events, such as death or divorce, COBRA beneficiaries receive 36 months of coverage. COBRA coverage may be terminated if the employee does not pay premiums on time, the employer stops offering a group plan, or the qualified beneficiary becomes entitled to coverage under another health plan. After a qualifying event, the employer no longer pays any share of the health insurance premiums it had contributed while employed. So although terminated employees and their families maintain their health coverage under the employer's plan, the employee must pay the premium, potentially plus a little extra for administrative costs. People who cannot afford the price of COBRA coverage may be entitled to a tax credit that can offset premium payments by over 70%. This health coverage tax credit may be claimed on an income tax return at the end of the year. Some states have laws like COBRA that expand former workers' rights to ongoing health care benefits, so workers should be aware of any additional entitlements offered to employees in their areas. Keep in mind that in some circumstances, workers who are eligible for COBRA benefits may have more affordable or generous coverage options available through Medicaid, the health insurance marketplace, or other group plans. So people leaving jobs should investigate other possibilities for health coverage rather than assuming COBRA is definitely the best way to go. The Health Insurance Portability and Accountability Act of 1986. Like COBRA, an important purpose of the Health Insurance Portability and Accountability Act, usually called HIPAA, is to protect employees from losing their health care coverage when they change jobs. HIPAA offers additional protection to workers enrolled in employee-sponsored group health plans. Under HIPAA, workers who lose employer-sponsored healthcare coverage may have the opportunity to enroll in new healthcare plans before the next open season for enrollment. Under HIPAA, a person who previously declined health coverage for himself and/or dependents, but then undergoes a change, that change may trigger a special enrollment opportunity in his current employer's group health plan. Special enrollment opportunities are triggered by any of the following. 1. A loss of eligibility for health coverage under a health insurance plan. For example, if a worker is covered by his spouse's plan, and his spouse's employer then stops coverage or stops contributing to premiums, this would trigger a special enrollment opportunity. 2. Gaining a new dependent through marriage, birth of a child, etc. Or 3, losing eligibility for government-provided health coverage, such as Medicaid, Children's Health Insurance Program, or similar program. When a special enrollment opportunity is triggered, the employee's current employer must offer him the opportunity to join in coverage currently offered by the employer, even if the employer previously declined that coverage. From the triggering event, the employee has 30 days to make the decision as to whether to enroll. If the employee accepts coverage, it must be made available as of the first day of the month following the election. HIPAA also limits insurance exclusions for pre-existing conditions and prohibits discrimination against employees based on their health. Moreover, HIPAA's non-discrimination provisions prevent a person from being charged more for coverage than a similarly situated person covered under the same plan based on health status. Health status includes medical conditions, prior receipt of health care, medical history, genetic information, and disability. HIPAA also protects workers' private health-related information from disclosure except with consent or under other limited circumstances. Retirement benefits. Workers typically retire after participating in the workforce for their employable life. To ensure that retirees receive benefits and payments sufficient to allow them to support themselves, the United States and many other developed nations have laws in place regulating retirement plans. Nearly all elderly Americans are eligible for Social Security, a government retirement program funded by payroll taxes. Employment-based retirement benefits, on the other hand, are voluntary benefits that are commonly offered to a worker as part of a compensation package. Social Security. Nearly all American workers qualify for Social Security. People who have worked in at least 40 quarters become eligible for full retirement benefits at age 67. But people can retire early and receive some Social Security benefits as early as age 62. Workers age 65 and older become qualified for health care coverage through Medicare, a benefit related to Social Security, and this applies even if they don't retire. After retiring, workers are entitled to monthly Social Security payments based on how much they paid into the system during their careers. So a worker who pays more into the Social Security system will be entitled to larger payments upon retirement. Social Security benefits are typically only about 40% of pre-retirement income. So workers who wish to retire at a more comfortable income level may wish to look for ways to supplement these payments. The Social Security system is being underfunded due to a change in worker demographics. Workers and employers each contribute 6.2% of the worker's pay, for a total of 12.4%, to Social Security's National Pension Plan. Because retirees draw from a pool of resources funded by current workers, the system depends on a certain ratio of employed workers to retirees. In 2014, Social Security was underfunded by $34 billion, putting the program on track for bankruptcy in 2035. While Social Security benefits are currently available to nearly every American retiree, the future of the program remains uncertain. As a result, private retirement plans are becoming increasingly more common. Private retirement plans. About 60% of American workers participate in retirement plans at work. Employers or employee organizations can establish and maintain private retirement accounts that provide income for workers at the end of their careers. These funds can be organized as traditional pensions, individual accounts, or group funds that both employees and employers contribute to. State and federal agencies monitor these private retirement plans to ensure that they're being managed appropriately. The Employee Retirement Income Security Act, or ERISA, empowers the Department of Labor to administer and enforce federal protections over employee benefits. ERISA sets minimum standards for voluntarily established private pension and health plans necessary to protect people who are enrolled in these plans. The law requires retirement plans to provide members with information about key features and funding sources of the plans, creates fiduciary duties for retirement plan managers, and gives participants the right to sue on these bases. It also requires the establishment of grievance and appeals processes for participants seeking to derive plan benefits. These measures all protect individual participants from possible mismanagement of funds committed to employee retirement or health care. However, ERISA does not typically cover group health plans maintained by government entities, churches, organizations outside of the United States, or those maintained solely to comply with workers' compensation, unemployment, or disability laws. COBRA and HIPAA both amended ERISA to require the continuation of health care under circumstances where a worker's coverage under an employer-sponsored group health insurance plan was discontinued. ERISA covers two distinct types of pension plans: defined benefit plans and defined contribution plans. Defined benefit plans guarantee a specific amount per month upon a contributing employee's retirement. Commonly, defined benefit plans apply a formula considering factors such as salary and years of employment to determine the monthly payments. For example, an employee may be entitled to 2% of his or her average monthly salary for every 7 years that she was employed at the company. Many pensions negotiated by labor unions through collective bargaining are organized as defined benefit plans, as these types of plans put responsibility on the employers to fund and administer the programs. Defined benefit plans also more commonly pay retirees through an annuity, while defined contribution plans, such as 401k accounts, typically entitle the worker to unlimited access to the account. Under a defined contribution plan, the employee, employer, or both contribute to an employee's account, and the employee may draw on the balance of the account after he retires. The employee's account typically gains value through the management and investment of financial professionals. Profit-sharing plans, employee stock ownership plans, 401k plans, and 403b plans are all examples of defined contribution plans. A 401k plan is a defined contribution plan under which the employee can voluntarily defer receiving a portion of her salary so that her employer may contribute it to an investment account. Employers often match these contributions up to a certain percentage to encourage retirement savings. Employers must advise workers enrolled in 401k plans about the several regulations and limitations that apply to these types of investments. Another type of defined contribution retirement plan is known as the Simplified Employee Pension, or SEP IRA. Employers may make contributions with favorable tax implications to employee-owned individual retirement accounts. Unlike 401ks, the employee sets up the SEP. Alternatively, employers may set up simple IRAs, which allow businesses to contribute portions of workers' salaries to the retirement plan in a fashion similar to the 401k. Overall, there's been a substantial decrease in employer-funded defined benefit plan and an overall shift towards defined contribution plans. The main reason is that employers don't want to be responsible to ensure the funding of the plan and the growth of its assets. In the case of the defined benefit plans, the employer is on the hook if the investments go bad, because they're required to provide predetermined benefits to employees upon retirement. Because defined contribution plans place more responsibility on the retiree, workers may want to be involved in the management of their retirement accounts, and if so, should be aware of the options available to them. Transferability. Contribution-based retirement plans are easily transferred. Because employees own their retirement accounts, they can easily transfer their accounts in the event they separate from their employers. However, they typically may not simply withdraw their account balances, as doing such would trigger severe adverse tax consequences. For example, in the case of the traditional IRA, 401k, or SEP IRA, withdrawing assets before age 59.5 subjects those assets to income tax and a 10% penalty for early withdrawal. Fortunately, employees leaving positions who have 401k accounts have several choices. They include 1. Leaving the account as is with their former employers. While the former employer will naturally no longer make contributions to the account, it can still grow and the employee does not lose access to it. Option 2 would be cashing out. Withdrawing the money is not usually a good idea because of the tax and penalty consequences. Option 3 is rolling it over into a 401k plan with the new employer. If the new employer offers a 401k plan that the employee is satisfied with, this would generally be an excellent option, especially because the new employer would make its contribution to this existing account. And option 4 is rolling it over into an IRA account, which is then treated as a traditional IRA. This option may slightly decrease flexibility in limited circumstances, but is often the best strategy when the employer does not offer a 401k plan that the employee intends to participate in. In contrast, defined benefit retirement plans are not as easily transferred, since these types of retirement benefits are drawn from a single account that covers an entire workforce. Often, when workers leave jobs with defined benefit retirement plans, the portion of the retirement fund to which they are entitled is transferred to an IRA in the employee's name. Conclusion. While job transitioning can be stressful and difficult, rules such as COBRA, HIPAA, and rollover IRA allowances are important mechanisms by which the law seeks to allow people transitioning jobs to maintain their healthcare and retirement benefits to the extent practical.